This panel is a crossfire exchange on the use of force to stop genocide, and you'll see behind me some images of what is probably the most recent and ongoing genocide where there is a lot of talk about the use of force, and that is the situation in Darfur. Hopefully that's one of the themes that's lingering in the background of the discussion today. Let me introduce the chair of this panel, Melissa Waters, who is currently a visiting professor at Vanderbilt. Her home institution is Washington and Lee Law School, but she, like President Barbara Snyder, began her academic career teaching right here at Case. She also worked previously at the State Department as the senior advisor to the Assistant Secretary of State for Human Rights, Harold Koh. Her articles have been placed at some of the most prestigious law reviews in the world, Columbia, Georgetown, University of North Carolina, making her one of the rising stars of our academy. And it is our pleasure, Melissa, to have you back at Case. Thank you.
Thank you. Thank you very much. Thank you, Michael. Well, as Michael said, I began my career here at Case Western, and so it's a particular delight to be back here amongst my old friends. I can say quite honestly that I feel tremendously fortunate to have begun my career here. I cannot think of a kinder, more gentle place to begin one's academic career, and I had the great pleasure, particular pleasure, to work with Michael for 2 years after he arrived at Case several years back. And again, can't imagine a more supportive, more wonderful senior colleague. I still think of Michael as my role model for what a law professor and a member of an academic community should be like, aspire to be like him. So it's a great pleasure to be here. And I'm particularly delighted to be the moderator of this panel, which I think really occupies sort of a unique space in this conference, because it focuses not so much on issues of accountability, what do we do with perpetrators of genocide once we've managed to catch them, but instead on this question that I think has really sort of tantalized and frustrated the international community for decades now. What about the possibility of preventing genocide in the first place? Can we do that? How do we go about doing that? What are the possibilities and the limitations, in particular for using military force, right? Seems like such a simple proposition. Let's use military force and just stop these perpetrators of genocide in their tracks. Of course, it's not quite so easy. Throughout the 1990s, the doctrine of so-called humanitarian intervention, the use of military force to stop genocide and other forms of mass atrocity, was a major topic of debate among international lawyers and legal scholars. Bosnia, Rwanda, Somalia, Kosovo, Sierra Leone. What should we have done? Did we do enough? Could we have done more? When we did act, how effective were our actions? When we failed to act, why did we fail? With the arrival of the sort of post-September 11 war on terrorism, though, I think humanitarian intervention, the debate over humanitarian intervention, has become even more complex. Many observers, I think, expected humanitarian intervention to move away from center stage in the international community as the United States and other powerful nations around the world became much more interested in their own immediate security concerns. The past few years, though, I think have really witnessed renewed interest in the subject of the use of military intervention to stop genocide. The United Nations, and I think we'll talk about this on this panel, has begun to take very important steps to recognize what it now calls the responsibility to protect populations from genocide, and military interventions in the Democratic Republic of the Congo, in Liberia, in Cote d'Ivoire have been justified largely on humanitarian grounds. More controversially, of course, supporters of the war in Iraq recently have begun to contend that the invasion there might actually have been justified on grounds of humanitarian intervention. And of course, we've already heard this morning, and I think will throughout the rest of the day, about the issue of Darfur. The international community has said, yeah, genocide is occurring there, but what have we done to stop it? Have we done enough? What more could be done? And should there be a role for heightened military intervention there? So our Crossfire Exchange today is going to address these issues. What has the international community learned over the past couple of decades about the possibilities and the limitations of the use of military force to prevent genocide? And how do we distinguish the situations where military intervention would be appropriate and effective from those where it's simply going to be futile. What's the role of international law here, and has the international community done enough to develop legal principles, international law rules regarding military intervention? And so to address these issues, we've got just a fabulous lineup of real experts on these issues. I think we're in for a real treat with this panel, as with all of the panels. So let me introduce them now. You've got their bios. I'm just going to hit the high points because otherwise we would be here all day. The first of our panelists is Roy Gutman, who is a journalist and currently foreign editor at McClatchy Newspapers, Washington Bureau. Prior to joining McClatchy, Roy had spent, I think, most of his career with Newsday, serving as Newsday's national security reporter in Washington, as the European bureau chief in Germany, and as Newsday's foreign editor in New York. And over the course of his career, as I'm sure you all know, Roy has won just about every major and minor award that they give to journalists, including, of course, in 1993, the Pulitzer Prize, well-deserved honor for his coverage of ethnic cleansing and death camps in Bosnia. He's also the author of several books, including A Witness to Genocide, based on his reporting in the Balkans, and Banana Diplomacy, I love that title, on U.S. policy toward Nicaragua during the Reagan administration. And if I'm not mistaken, he's also working on a forthcoming book chronicling the rise of Osama bin Laden. Yes, and last but not least, Crimes of War, which I think is with David Reif, which is a book dealing with what the public should know, right? So very much a book to try to get the word out on these important issues. And Roy, I think, is also the director of the Crimes of War Project, which brings together reporters and legal scholars to increase awareness on issues involving the laws of war. And then our next panelist, going in order here, is Paul Williams, who is the Rebecca Grazier Professor of Law and International Relations. He holds a joint appointment at American University in Washington, D.C., where he also directs the JDMA program in international relations. Paul is the co-director, along with Michael Scharf, of the Public International Law and Policy Group, which we used to call PILPIG, until Paul decided that that didn't sound so nice. So it's now PILPG, I think. PILPG is a nonprofit group that provides really just amazingly impressive pro bono legal assistance to developing countries and countries in transition who are involved in or emerging from conflict situations. And he and Michael and the co-directors at PLPG were nominated for the 2005 Nobel Peace Prize for their humanitarian work in contributing to the promotion of peace throughout the globe. Paul, through his work with PLPG, has served as a legal advisor to, among many others, the President of Bosnia on the implementation of the Dayton Peace Accords, the government of Kosovo on peace negotiations, and most recently as legal advisor to the chair of the Iraqi Constitution Drafting Committee. Next to him, we have Ambassador David Scheffer, the Mayor Brown, Rowe, and Ma, Robert A. Hellman, that's a mouthful, Professor of Law, and the Director of the Center for International Human Rights at Northwestern Law School. David served as the U.S. Ambassador at Large for War Crimes Issues during the Clinton administration, where I had the pleasure of working with him in his, with SWCI, as it was called. He led the U.S. delegation in UN talks to establish the International Criminal Court and is really just one of the world's foremost experts on the International Criminal Court. As ambassador, he also negotiated, coordinated U.S. support for the establishment of international criminal tribunals around the world, and also served during the first term of the Clinton administration as senior advisor and counsel to Madeleine Albright when she was the U.S. representative at the United Nations. And then finally, last but certainly not least, down at the end, we have Mike Newton, who is a professor at Vanderbilt School of Law, and I'm happy to say currently my colleague at Vanderbilt, where I'm visiting this semester. Mike came to Vanderbilt having served previously as an associate professor of law at the U.S. Military Academy at West Point, from which he also graduated. Prior to entering academia, he served as senior advisor to the United States Ambassador at Large for War Crimes Issues, or SWCI, during the Clinton administration, where he specialized in issues relating to the International Criminal Court and the Sierra Leone Special Court. And Mike is really one of the world's foremost experts on the Iraqi legal system. If you want to know anything about the Iraqi legal system, Mike is your man. In particular on issues of accountability in Iraq, having worked closely with Iraqi lawyers and judges on these issues since the year 2000. So really just a wonderful panel I think we're in for a real treat here. So let me just kick this off. This is a crossfire panel, of course, so we're going to just launch right into it. It strikes me that there are sort of three broad issues, three broad criticisms that might be made of the use of military intervention to stop genocide. First of all, what's the basis under international law? Is it permissible under international law, or do we have to resign ourselves to declaring that, well, it's illegal, but it's legal because it's morally justified? Second, does military intervention to stop atrocities work? And third, what about specific examples? Can we take the broad legal concepts that the UN and others have developed regarding the use of humanitarian intervention, and can we actually apply them in any practical way to specific situations in Darfur or Iraq, that sort of thing? So let me kick off the panel with the question of whether military force to prevent genocide is justified under international law. Can we find a basis in international law to justify humanitarian intervention? And let me start with you, Mike Newton. My understanding is that the UN Charter says there are only two acceptable kinds of the use of force. One, of course, is if the Security Council authorizes it under Chapter 7. The other is self-defense under Article 51. As far as I know, neither one of those humanitarian intervention falls under neither of those categories. So where do we find legal justification for this principle?
Well, it doesn't quite say that. That's the way we've interpreted it and applied it in practice. The presumption is, and we take for granted the familiarity with the responsibility to protect, that we need to find a mechanism within the context of international law, which is the basis of your question, to have normative regularity that tells us when and how and what are the legal constraints. The disconnect is between the normative regularity that we've developed with regard to the actual substantive crimes. Right now we have a substantive database of crimes that we can say. Now the disconnect is in terms of appropriate and effective prevention and mechanisms to address and prevent those crimes and repress those crimes. There's a normative disconnect. The one biggest place in the Charter that I think is currently unexplored is Article 25. In practice, Article 25 clearly says that all nation states have the legal obligation, not just right, but obligation, to accept and implement the decisions of the Security Council. Well, if you go back to Resolution 1674 and the other language and responsibility to protect, the Security Council has an affirmative obligation to specify clearly when crimes against humanity, war crimes, and genocide are occurring, and to urge states to take measures to repress and address them, both at the preventive and the responsive stage. Well, if you take Article 25 seriously and follow it through to its logical conclusion, then states have a unilateral authority to then take action based on that specific finding of the Security Council, with or without a specific mandate to intervene. Article 25 says it on its face. That may be controversial in practice, but I think as long as you're restricted to a comprehensive multilateral system, it becomes restrictive, and in practice, if you're, as you posited, the goal is appropriate and effective, I think that relying on Security Council specific mandate every single time is not effective in the long term.
David Scheffer, would you agree with that? Would you find Article 25 to be a basis for humanitarian intervention, or would you look elsewhere?
Well, it's a perilous argument, as much as I respect Mike's putting it forward, because it would tend, if you were to embrace Article 25 as your premise, you would in a sense be negating the significance and relevance of the whole Chapter 7 construct of collective security within the UN Charter, whereby actually following through with the Article 25 obligation is set forth in Chapter 7 on a procedural basis. How do you follow through with that? Well, you follow through pursuant to the procedures that are set forth in Chapter 7, which are essentially collective security procedures, although in Article 51 you have your right of unilateral self-defense, but then you still have to check back with the Security Council, report upon it, and the Security Council can check you on your act of self-defense if it wishes to, and you must comply then pursuant to the Charter with the Security Council's judgment. I would also, however, note that if we want to sort of try to think on the edge here as well, there is, we often talk in individual criminal responsibility issues and in human rights issues, this notion of civil disobedience and accepting the consequences for it. Therefore, it is possible that at the state level, at the state responsibility level, decisions are made whereby, yes, you know that you're going to contravene the technical requirements of the law, the legal requirements of the law, because you're taking a gamble. You're taking a gamble that genocide may occur and needs to be prevented, and you're going to take the gamble to react to that and take a step in order to follow through on a preventive measure, because on the one hand, you're weighing your Article I Genocide Convention responsibility against your UN Charter non-use of force, and you've got to gamble. When you take that gamble, there can be at least two outcomes. One, you may realize the acquiescence of the international community in your gamble, and there's no real legal consequence for you as a state with respect to that. The interesting twist now in the 1990s and early 21st century is that the state may avoid responsibility, but the individual leader may get trapped within a criminal responsibility. So it's a little dicey. But the second thing is that you can also realize an ex post facto validation. In other words, not acquiescence, but rather somewhat similar to what we saw in Kosovo, where we had a situation, and even the Iraqi intervention of 2003, where the Security Council acts in the aftermath in such a way that you begin to at least validate the presence of the military forces on that territory. Whether that's right or wrong, I'm just saying that there's a technical procedural issue there of validation that may result. I just want to make one last point on this. Article 51, collective self-defense. I think that's greatly underused for this purpose of humanitarian intervention, of trying to prevent genocide, in the sense that I don't think governments imaginatively use it to say, I need to go in there. I don't really think I should go in unilaterally. Who can I talk to in the neighborhood that can request our assistance in order to develop a collective self-defense? Because genocide so often results in refugee flows. I think the outer edge of that argument is we don't explore enough the concept of collective self-defense of peoples. In other words, what if there's an appeal from a people, the refugees of Darfur, that we need the support of the international community to retake our territory? It's not a governmental request, it's a people's request. That's on the outer edge of international legal theory, but I think it's something we have to explore in this context.
Paul Williams, I'm curious what you think about this last assertion, that, well, collective self-defense, I'm very intrigued by it. Collective self-defense could mean, well, you look not at the sovereign nation, but beneath, sort of beneath or underneath the sovereign nation, at the people themselves. Do you buy that, or is that undermining traditional notions of sovereignty too much? David says, well, it's at the outer edges of international law. Is this something that we should move a little closer into the inner edges of international law or not?
Yeah, no, I think David's brief comments highlighted the fact that we're stuck in this conundrum of continually going back to the United Nations, the Security Council, traditional norms of sovereignty. We've got Darfur flashing behind us on the screen. What is the Security Council? What have UN institutions done on that issue? And in some of the later questions we'll talk about that. We have Burma. The Security Council has rallied its soul to basically ask the Burmese government to, kind of go gently on the monks.
Yeah, for like a decade now.
They raided monasteries and beat them up and killed a few of them.
Right.
And I think that I would encourage David to not characterize, I actually agree with the way that David is going, but would encourage us as lawyers and as journalists and as advocates not to put these other alternatives out on the fringe in the same way that we've embraced this responsibility to protect, which essentially lacks a legal basis, and I'll talk about that in one of the subsequent questions. I think we need to be much more creative and much more aggressive in finding moral bases, legal bases, justifications for intervention, be it military intervention, be it judicial intervention, be it other types of interventions, because we are faced with a constant wall of accommodation and appeasement, which is deeply entrenched. And we're seeing that now with the Save Darfur crowd. We all walked across the chalk written this morning on the patio that says, divest now. In my office at the law school, I have one of those little red ribbons that my wife gave me on our first date to divest from South Africa. And it was amazing how the entrenched interests were apartheid, well, it's not that bad, and oh, divesting from South Africa is not a good thing. And now South Africa is the model case study for transitional norms of justice, post-conflict societies, all of these things. And you're going to see that with Darfur. You're going to be amazed at the response that you get and why, well, you really can't divest from companies involved in Darfur. You know, the genocide's over, so why should we be bothering focusing on that now?
Well, let me ask you a follow-up question on that.
You wanted me to be controversial. So
I did. I'm glad that you are being. But let me just ask you. You know, so you say, well, you know, I think we need to think more aggressively about not only. So I hear you saying two things: more aggressively about being willing to use military action. I think I don't know if I'm putting words in your mouth, but I think that's what you're saying. I'll go ahead. But also more aggressively about finding legal justifications for that. And David, I think that's what you're saying as well. Let's really try to find these legal justifications. But it strikes me that we can't even decide what the proper terminology is. So, for example, you know, I didn't, as I was preparing for this, I didn't know whether to talk about humanitarian intervention or about responsibility to protect, because I'm told that the term humanitarian intervention has become quite passé around the United Nations these days. Paul, can you tell us what's the distinction between humanitarian intervention, responsibility to protect, and what's the significance of the different use of these terms in the United Nations?
I think to even take your question a step back, I think that if you look at the history of how we evolved from humanitarian intervention to responsibility to protect, it lays bare a number of concerns that we're facing as we try to grapple with constructing a new norm of intervention. And quite frankly, the ability to construct this new norm has been hampered by the very aggressive efforts of member states of the United Nations, U.S. government officials and others, to erode that moral imperative to use force to stop the early genocide in Bosnia and the subsequent crimes against humanity in Kosovo. You know, back in the Bosnian days, and Roy knows this very well, there was ample, clear authority in the UN Security Council to take action to stop what was happening in Bosnia. This was met by a very aggressive effort by Warren Christopher in the U.S. Department of State, by the Secretary General of the UN, to erode that moral imperative, to obfuscate the legal ability to actually engage in humanitarian intervention, to define self-defense as self-defense of the peacekeepers, but not self-defense of the safe havens and enclaves, hence Srebrenica, hence genocide in Bosnia. You fast forward to Kosovo. Despite a fairly clear legal basis for humanitarian intervention in Kosovo, the Office of the Legal Advisor, the State Department, refused to give a legal justification to the U.S. government for engaging in humanitarian intervention. You've now had a shift, and then you had the Europeans, our European allies. Well, it's not legal, but it's legitimate. It doesn't really work as a legal basis for future humanitarian interventions. So with this tension between sort of the norm of human security and the more traditional norms of sovereignty, they shifted to this responsibility to protect. Well, humanitarian intervention, since the final word is not legal but legitimate, let's shift to something new called the responsibility to protect, which is essentially that there's an inherent duty in state sovereignty to safeguard the lives of civilians. And if a state is unable or unwilling to do that with UN blessing or UN authorization, the international community or members of the international community can take action, such as use the force. Well, now the problem here is the rationale has morphed from humanitarian intervention to one of responsibility to protect, and you've transformed this debate from one about a responsibility to intervene to sort of a duty inherent in sovereignty, but you haven't established a new legal basis. They've oddly enough grafted on the old justification of a just war approach for responsibility to protect as opposed to a clear legal basis. So you're shifting into a political and moral basis. And interestingly, just as the just war approach placed the right authority with the Pope, you have those who are arguing for responsibility to protect, placing that right authority with the UN. And quite frankly, I think misplacing it with the UN and thereby handicapping it at the very early stage and limiting its ability to actually promote the norm of human security.
So you're skeptical of this shift to responsibility to protect?
It's essentially a shell game without dealing with the underlying reluctance to protect, to use interventions, military or judicial, to promote and protect human security.
Responsibility to protect is a shell game. I'm curious, let me throw that open to the other panelists. Anybody want to quibble with that? Roy Gutman, please.
Well, not so much the responsibility to protect, but just some of the discussion, it seems to me, it sounds like we're looking for, there's a desire to intervene and we're looking for a legal justification. It seems to me one might try to do it, work from the law that exist, and I'm of course not a lawyer, but I recognize there's international humanitarian law, which is a fairly, it's a more and more developed body as time goes on, as well as the law of nations, which is incorporated in the UN Charter. It seems to me that the IHL itself gives you both definitions of what crimes are and obligations to stop them. The law of nations does not, because it's much more, a kind of a procedure of when you use force. And I'm not quite sure, maybe somebody can define for me, which is the superior body of law. How does each body define the other body and where it stands? I'm not sure that they do at all. And I recall during the Kosovo debate that these two seem to be up, eyeball to eyeball, and it's a question of who would be the superior, under which body of law would the U.S. and other countries intervene. And I think they went for IHL in that particular case. And it seems to me that IHL gives you a lot to go on, and you could just start with it. And if there are crimes of a systematic and widespread nature that they constitute crimes against humanity, why not use that as the definition of an obligation at that point to act? And then you have to find some way under the law of nations. But start with IHL, which has got an awful lot of valuable content.
Well, I mean,
Yeah.
the UN Charter in itself, and this is often forgotten, we talk about, as Paul pointed out, the right to protect as a new principle, which in some sense it is in terms of its formal adoption and formal development and substantive content. We can talk about it today in a way that we couldn't 2 or 3 years ago because we know what we're talking about, right? We've got the World Summit, we've got the UN Security Council resolutions, et cetera, et cetera. But the UN Charter itself is not a values-neutral document. Right? It clearly elevated sovereign concerns, the principle of respect for sovereignty and territoriality, but it also, if you read it, has a very, very deep strand of concern for the human dimension, which over time became frustrated by the pragmatic realities of dealing with the constraining effects of the politics inside the UN. And to that extent, I think Paul is right. If you take responsibility to protect and you say, well, we've achieved something, because we've now recognized and revalidated the human dimension as opposed to the pure concern over sovereignty. Great, we've achieved something. If you just leave it there and say, okay, the paralyzing, constraining force of and here I disagree with Dave. If we say the only way we can do this is in a collective sense, what we've really said is we share the moral concern that we shared in Rwanda. We share the moral human concern and the human dimension, and yet we've put ourselves into a legal box where we're entirely constrained on a whole range of resources, so that unilaterally states can do really very limited things unilaterally, but in the ultimate steps of what really works in a particular context to prevent and repress. If we're serious about saying prevent and repress, you've got to tinker with the UN mechanism. Mm-hmm. And to the extent that we don't, Paul's right, it's just a shell game. We've changed terminology.
But I think there's a misunderstanding here. And it's exactly why I talked about acquiescence and ex post facto validation. You can act unilaterally to advance the principle of responsibility to protect and to respond to mass assaults on civilian populations who are subject either in real time or the real threat, imminent threat of atrocity crimes. But then the issue, I think, from a lawyer's point of view is when you do so, will you then be able to fall into any conventional framework of justification for the use of force? And what I'm suggesting is, from a pragmatic point of view, if the result is that there's acquiescence in what the state has done unilaterally or collectively, or there's an ex post facto validation of what that state has done, then you probably shield yourself from the worst consequences of an illegal action, and history will bear out the truth and justice of what you have done. I think the difficulty we all have, although I don't know, maybe Paul would just charge ahead, is can we create any legal framework within which when you take that gamble, you are taking it, even unilaterally, with full justification and legality in taking the gamble, because you don't necessarily know what will happen next week or 2 weeks from now on the ground, and whether it will rise to the level of a requirement for sustained intervention militarily, which brings me back to the other options, which is that you always keep on the table your economic options, your judicial options, your political options, et cetera, in the whole basket of responsibility to protect tools.
It strikes me, as I hear you talking about this, that particularly with Mike's comments, that in a sense it's a question of just how flexibly do we interpret the UN Charter here. It strikes me as being somewhat analogous to, you know, the ongoing fight between Justice Breyer and Justice Scalia about a living constitution or not a living constitution. Do we have a living UN Charter or not? Let me move on, though, and talk about, in practical terms, even assuming that we can find a legal basis for the doctrine of, I suppose now, responsibility to protect rather than humanitarian intervention in broad terms, how much has the international community learned over the past couple of decades about the use of military intervention as a weapon or as a tool to prevent genocide? Does it work? And more specifically, in what context does it work? And in what context is it doomed to failure? And Roy Gutman, let me bring you in here. Have we learned anything from the past 2 decades on these issues? For example, how long do we seek the use of peace talks to stop atrocity crimes before employing military force? Have we gotten any better at knowing when's the sweet spot? When is the appropriate moment to intervene?
Well, I'd like to come back to just the thesis I was propounding earlier about just the importance of understanding humanitarian law as a starting point to understand when peace talks work and when they do not. Mm-hmm. It seems to me that the first thing, and I have a slightly journalistic prejudice here, but I think that people will agree that what matters most in terms of public opinion and actually and eventually governments is what is actually happening. What are the facts on the ground? And if there's a determination that there are crimes against humanity, you know, going on that could lead to genocide, or that may be the precursor of it, or systematic war crimes, you know, which is another branch of the same kind of attitude of willingness to violate law. That first of all, we need to know what those facts are and whether there really is a pattern and whether it's extensive. Then the second action that governments must take basically is to determine, and this really probably has to happen at the Security Council level, how to protect the population which has been targeted. And there are many different ways to do this. You know, as David was just mentioning, you could have sanctions, you could have judicial measures, but you may very well have to use force or somehow allow force to be used to protect that population. And it should be used at the lowest possible level that's feasible. And it might be arming those who are being attacked, or allowing those people to be armed in the first place so they can protect themselves rather than going to an intervention. It seems to me that peace talks in a context like this, and I go back to the Bosnian one, which is maybe one of the most egregious uses of peace talks, it sometimes is a camouflage. It's a cover for doing nothing, for pretending that you are acting, for explaining to your public we are really active, and certainly the UN itself as a body, and the major powers in the course of 4 years in the 1990s were using peace talks as a cover. It seems to me, so, and this is deceptive, and it's rather hard even for us, you know, the most critical journalists out there trying to determine what is really going on in the talks, because we don't know the big picture. We only know what they're telling us and what the different sides are telling us, and it's rather hard to reach a judgment. But peace talks, I don't think on the whole are going to stop atrocities. Any government that decides it's going to break laws and do it in a systematic way is doing it for its own agenda. And peace is not the issue. Governments which commit these crimes tend to be the stronger party, for one thing. And they don't, and they're not going to be curbed, you know, over some negotiation with the victims. It's just not going to happen. So essentially, peace talks are probably a diversion. And I would come back to the point that What matters here most is what is happening on the ground. What are the facts? When Sharif Bassiouni and the Commission of Experts started assembling material on Bosnia, for example, I think that was an invaluable exercise that allowed everybody to recognize the facts. And then what you do about it is a second question. But peace talks hardly likely to succeed.
Interesting. So peace talks are a diversion that at best, if I'm not putting words in your mouth, at best allow genocide or don't do much to prevent genocide from occurring, and at worst actually provide cover for to allow the genocidal maniacs to continue killing people. Paul Williams, do you agree with that?
Well, you would encourage us to have a crossfire panel to disagree with our colleagues. But since I don't disagree with anything Roy said, I'll disagree with you.
Please do. Even better.
Your question starts with the presumption that you should have peace talks, and that at some point, if they're not working or not playing out, you may want to switch over to humanitarian intervention. And I would like to put on the table the possible argument, like Roy has, that sometimes you simply should not have peace talks. In some instances, there is no such thing as getting to yes with war criminals. And you have to engage in some type of humanitarian intervention, be it David's list of economic intervention, and then intervention along the lines of accountability, and then maybe limited and targeted military intervention, and maybe sort of more aggressive of military intervention. If you look at sort of the road to genocide in Bosnia, it really is littered with the tombstones of nearly a dozen peace agreements. The EU Troika team that was sent down, the Briani Agreement, the London Principles, the Geneva Accords, the Vance-Owen Proposal, all of these agreements that led to Srebrenica and the other elements of genocide, or instances of genocide, before you finally got to the Dayton negotiations, which occurred after the military intervention. And the same with Rambouillet. Rambouillet was signed here, Kosovars, so we can then have a humanitarian military intervention against Serbia to bring them to the real peace talks. Some of the concerns that I would like to emphasize that Roy had pointed out is there is this theme. We're sort of putting responsibility to protect humanitarian intervention out there. That will be met with mediators saying, whoa, 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 I'm saving lives. We need these negotiations because we're saving lives. Your irresponsible talk of the use of force, economic sanctions, it interferes with my ability as a mediator to save lives, which then can tend to slippery slope into accommodation. We need to accommodate the interests of all of the parties. We need to accommodate the interests of the aggressor party because they're the strongest party, which then slowly slips into appeasement and some may argue even complicity. And stepping out of my words and using someone else's words, there's a lot of information out there now from a former senior official in the tribunal about the possibility of an immunity deal between U.S. government officials and others, and Karadzic and Mladic, that they had worked out with Milosevic, which dramatically undermined all of the things that those of us in this room are working for accountability, never again, accurate historical record. I don't have any information on that, but there seems to be a lot of information out there. The journalists will help bring that along, about whether there was a deal as part of the peace talks to grant essential immunity to Karadzic and to Mladic. And so those are my concerns with, yes, sometimes you need peace agreements, but don't assume that you need a peace negotiation before you can look at these other elements.
Maybe you need military intervention first.
In some instances, we can talk more about Darfur maybe in the Q&A.
Yeah. So I see we have
Tripoli negotiations. Genocide is cruising right along in Darfur. We're going to have Tripoli negotiations.
So I see we have a couple of steely-eyed realists on the panel. I'm curious whether we have a full panel of steely-eyed realists on these issues. David?
Well, I'd like to join that crowd because I'd like to just bring the pragmatic reality. When you're sitting in the State Department dealing with these issues, and Paul was there, obviously, and so was Mike, there is an enormous amount of pressure at that table up on the 7th floor. It's usually the Deputy Secretary's conference room, where you sit there with your colleagues from the political bureaus and the other the political military bureaus, et cetera, of the State Department. And if you walk in and try to make the case that human rights or the survival of this population is at stake and we need to act very unconventionally within the next 48 hours or else we're going to lose it, you will get the response that Paul is talking about. The whole political bureau apparatus will come down on you like 20 elephants, and they'll say, wait a minute, now we've had a peace process going, we're talking to the parties, we've got feelers out, we're going to do this and that. That's exactly what we saw happen. I mean, not quite that dramatically, but I can remember those key months in 1994, January, February, March, leading up to the Rwandan genocide, where everyone in that sort of cocoon of discussion was banking so much on the Arusha peace process and not really looking at what all these other signals were, because there was such enormous hope, but also sort of comfort in the peace process being the answer and nothing else. It was very conventional. And they love to bring conventional points to the table and prevail.
Well, times 4. I mean, I'm a pragmatic now. Except I want to take it to the next order of magnitude of difficulty, right? David focuses on the interagency process and on just what you will hear in discussions. Realize that we live in a world where the kinds of people who are predisposed to commit these crimes, the regime elites, who have the institutionalized systems of oppression that are necessary to commit those crimes on a wide-scale societal basis. Those are really the paradigms where we're talking about these kinds of things. They're not isolated, sort of limited instances. Those are precisely the kinds of people who will sometimes say verbally, we don't care what you do or say in a collective diplomatic setting. This problem is closed. This discussion is closed. And if they don't say it expressly, they will say it with their actions, right? You can pass all the resolutions you want. If you're limited to the constrained collective mechanism operating on consensus and the niceties of diplomacy, that's wonderful for you. I don't care because I have other interests at stake. If we're limited to that regime, then what we've done is we've built in a system of paralysis and a system of recrimination and a system, as we've seen in practice, this is Roy's point, that doesn't work. So we really can't have it both ways.
I want to move, since we're nearing, I think, the end of our time for the crossfire itself. I want to move to talking specifics. The question of the day, I think, one of the most crucial questions of the day for humanitarian intervention. What about Darfur? What have we done right? What have we not done right? What's the role for military intervention in Darfur? And I'll just throw that open to any member of the panelists who'd like to answer it. Deadly silence.
I'll go ahead and answer what we've done wrong, and then we let the
Paul, tell us, what have we done wrong?
In the old days, the word genocide used to mean something, and in the sense that David had talked about, that the Seventh Floor and others in the Balkans crisis would go out of their way not to use the G word, because then that would imply some obligation to do something about it. And I guess I've been surprised at the sort of slippage of that moral imperative. We have a situation where the former Secretary of State, the U.S. government, has said there is genocide occurring in Darfur. Okay, what's next on the agenda? Let's move on to the next. Oh, is it Thailand or is it Russia? It's sort of, there was a sense that simply calling it genocide constituted action
was enough,
and it was enough, and there was no sort of clamor for follow-on as to sort of what to do next. Also, I fear, and this is something we should be very, and I'm reluctant to say this in this crowd, but we should be very careful about how the institutions that we create, or many of you dedicate your lives to creating, are used to further erode that ability for some type of intervention to stop the genocide. And here I refer directly to the International Criminal Court. Okay, Colin Powell calls it genocide, and it's no longer the U.S. government or the State Department, it's Colin Powell called it genocide. And then the Security Council referred the matter to the ICC, which has investigated both sides, because you have to have a level of all sides are responsible, moral equivalency here, so there's not too much pressure to intervene. Okay, we've dealt with that issue. It's now a justice issue, not a humanitarian intervention issue. We've put it off to the ICC. I think the ICC has allowed itself to be used in that fashion and hasn't sort of taken on. It's been timid and tardy, just as the Yugoslav Tribunal was timid and tardy, in trying to seek to use the mantle of justice to prevent or to stop a genocide. And even now we have this very strange, and I've been trying to work Chris Joyner over to ask his panel this afternoon about this. There is the mantra that, well, there may have been genocide in Darfur, but it's ended. And we're doing some legal work on this, and we've had difficulty finding an answer to the question of, well, when does genocide end? And it's very easy for unnamed Western diplomats to say, well, the genocide in Darfur has ended, so now all these obligations, be they moral or from the Genocide Convention, have lapsed, and we can flip into the Tripoli negotiations and just sort out the post-conflict transition. So I think that we haven't really used these mechanisms we've been busy creating to actually try to stop or prevent the further genocide in Darfur.
But if the crimes were committed, and we know approximately what they are, and we have no doubt that they were systematic and widespread, then it seems to me something should be done about those crimes, and wherever, at whatever instance. And the ICC was actually a very useful body here. I was puzzled about when the administration decided to call this a genocide. I mean, whether they actually had the facts together that showed it, or whether it was a reaction to an unusual coalition that was constructed of their own inner core of constituents, namely the conservatives, as well as then a mixture of a whole bunch of others that came together in a fortuitous way, because they didn't seem, as you say, to have much conviction to do anything next. But I will say this: we're talking about how things went wrong, and they certainly did. I think, on the other hand, one of the most interesting facts about Darfur is that, and it shows really what happens probably in most every genocide, is that there's usually some outside party who is supporting the perpetrators in some way to give them enough comfort zone that they could just continue with impunity. And in this case, it seems to have been Malaysia to some extent, which was buying their oil, and certainly China, which was investing heavily and expanding. Well, this may be maybe we can chalk up one for diplomacy or whatever, but certainly the Chinese changed their tune. And they went into the Sudanese and demanded, in some form or other, that they accept the International Peacekeeping Force. We had a reporter in Darfur about 6 or 8 weeks ago. It was just about the time of this agreement. No, I can't say that the atrocities have ended or that the torture of the civilians has ended. But there was somehow a change. There was some change was in the air, and let's hope it comes about. But I do think that this is one of those rare cases where diplomacy also may have helped.
Well, David Scheffer earlier mentioned that states who choose to intervene militarily do so at their own peril and sometimes incur the wrath of the international community. In doing that, I'm going to exercise the prerogative of the chair and run the risk of incurring the wrath of Michael Scharf, who I know hates it when panels run long. But I have to ask one final question to the panelists, which I'm very intrigued by. What about Iraq? What sort of impact do you think the Iraq War has had on the doctrine of military intervention to stop mass atrocities? What sort of lasting impact will it have, if any? David Scheffer.
Well, I'd like to say that I do think it's had a devastating impact on the ability to move forward and advance with the responsibility to protect principle. Absolutely devastating. There has been an ex post facto rationale put forward that our intervention in Iraq had a lot to do with stopping the heinous character of Saddam Hussein's regime and, of course, the massive body of crimes that were committed by that regime. The record, of course, shows quite a very different story. That rationale was not advanced prior to March 2003. It was a WMD rationale. Everyone knew the politics behind that. And it became a convenient rationale in the aftermath as the first rationale collapsed. But the problem is that by using that rationale now, Iraq is such a tainted example of military intervention because of the manner in which it has been managed since the invasion that no matter how you might logically or academically argue that somehow we are achieving a humanitarian purpose in Iraq at this time, I think the world community is left with a very scarred impression of what our intentions were and what the consequences are of a military intervention. I'll just close this point by saying that whenever we talk about Iraq, we always have to say, well, we are where we are now. Whatever the mountain of catastrophe is, we can analyze that at some point. Now we're supposed to move on from one catastrophe, hopefully not to another. And I would simply suggest that this is a huge issue now in terms of how we plot our strategy forward. if we were to withdraw, there is the possibility of an even larger degree of killing and of atrocity crimes in Iraq. We have to recognize that. And the issue is it not our responsibility to deal with that issue in any strategy that is put forward? And what I have been advocating is, yeah, we've now got to go back to the international community, to the UN, and work through a methodology for how to deal with this situation. Despite all that's occurred up to this point, there is a clear responsibility not to let Iraq fall into total abyss. And we've got to plot our own strategy with that very much in mind.
Well,
Mike, you get the last brief word.
okay, undercutting the spirit of crossfire. I agree with David, but for a different reason. Right, if you take Iraq in the big picture context, what you have is a long series of very well-documented atrocities. I mean, massive scale, right? Lots and lots and lots. And the U.S. government documented, other governments documented. And to correlate with that, you have precisely what the responsibility to protect talks about, collective mechanisms, right? Lots of debate in all the UN organs and in Security Council, Security Council resolutions from here to the back of the room, completely ignored. And in fact, David's right in pointing out that a priori the humanitarian motive was not really credibly raised and argued by the administration. To me, that precisely points out the exact gap that we're talking about, right? That's an indication of how incredible that motive would have been under the current regime. And despite all the documentation, and the reality is sovereignty means something. And if, in fact, the responsibility to protect is posited as a sovereign obligation on the part of the state, well, conversely, when the bodies respect with the authority for implementing the compliance with those norms, sovereignty creates an obligation. It also creates the risk, the very real risk, that in not complying with that legal obligation, you run the risk of having it enforced upon you. Mm-hmm. And we are in a world today where we're paralyzed by inaction, where we can talk about it as a moral esoteric principle, but as a pragmatic reality, we're a long ways from where we want to be in terms of effective implementation. And I think the very fact that that wasn't raised as an a priori justification for Iraq in the clear face of what was the largest scale of atrocities, I mean, makes the pattern of activities in Darfur. It's a microcosm of that.
I see Michael stalking us, which means it's time to turn it over to Q&A. Please, any questions for this wonderful panel? Yeah, over here. Top of the room there.
I'd like to, if I could ask the panel your opinion on a current situation in Zimbabwe. And although perhaps not legally defined as genocide, certainly is defined in massive atrocities using kind of unique policies of Robert Mugabe. And yet, from the international community's perspective, it seems to be kind of a deafening silence about what actions should be taken. And in fact, it's not been mentioned at all. And I would just like to place that to the panel to see, well, what is our responsibility in preventing these atrocities?
Do you want to go first?
Well, I can say something about that. Again, I've had one of our reporters was in Zimbabwe, and in fact, in the previous job I was in, I sent a reporter into Zimbabwe. And so I have some idea of the facts on the ground. And I cannot tell you from the reporting of two separate people, plus an awful lot of other things I've read, that there are massive atrocities going on in Zimbabwe. What we do have there, clearly to my mind, is a tyranny of a political sort, where opponents are political opponents are jailed and tortured and mistreated, and maybe some have died in the course of the confinement. Of a totally incompetent government, which is impoverishing what was once one of the richest countries of Africa, and is totally disdainful of every other of all the rules of let's say just the Universal Declaration of Human Rights, which President Bush has been citing the other day. My take, again, I'm just going to give you a pragmatic judgment, is that until you have a clear and well laid out evidence in some kind of a record of crimes, of crimes against humanity that might presage a genocide, it seems to me one should not, as the international community, actively pursue the possibility of an intervention. I think you should try everything short of it. And one of the best ways is simply to look at a lot of things are going to have to happen within the country. Zimbabweans themselves are going to have to find some way to change or affect their government. Every country has its internal struggle at some point, and I don't think that one should wish to have international intervention here, there, and everywhere. We have to draw a line somewhere. And so my line is the lines that are drawn within humanitarian law. Crimes against humanity, genocide, systematic and widespread war crimes. And if you don't have those, in a really clear-cut way, then I think we should look for other means.
Can I?
To say that we don't have those types of crimes, short of genocide, being committed in Zimbabwe, I think is an excuse for the international community to continue to permit Robert Mugabe and his government on committing these crimes, and they are crimes.
Can I make a really brief sort of observation that I think needs to be explicit that Mark just captured, which is that if you really look at the responsibility to protect doctrine and you really talk larger, there is one evolution that's really important, right? The whole debate advanced beyond just the narrow concept of humanitarian intervention to this much broader concept of responsibility to protect, which involves a whole range of a priori mechanisms for preventing and repressing and identifying and informing and generating response and building judicial mechanisms and a whole huge range of identification mechanisms that can be done on a bilateral and multilateral basis, separate and apart, all of which has to happen at the prevention stage, right? You're not talking about let's let the situation develop into a crisis and then try to figure out how to solve it in remediation. The whole concept is that there is a fundamental human dignity that obligates states to work together through this whole other large, very large range of proactive, preventive responses. To the extent that we allow this whole debate to be just focused on humanitarian intervention, we create a paralysis. And
just to amplify that very briefly, the reality is we just have not done enough on Zimbabwe. You're absolutely right, Mark. I mean, the international community sort of stands partly in shame now when confronted with Zimbabwe. I would just say that with respect to, from a legal perspective, I do think that what has occurred in Zimbabwe fits within the responsibility to protect paradigm. It does do so. And I think if you look at it very, very closely, you can probably categorize a lot of what has occurred within Zimbabwe as a crime against humanity. So you can build your legal case. Within R2P, you could even go so far as a Security Council action under the outcome statement in 2005. The question is, would it then also legitimize a unilateral military operation? I guess at this stage, I'd want to explore everything Mike has just said, everything Roy has just said. I don't know if we're ready for that unilateral military step with respect to Zimbabwe. That's where the line is probably drawn.
Other questions? Over here, sir.
Nicholas Stewart, I get my chance from down there this afternoon, but since the chairman of my session asked a question just now, I feel more comfortable I would follow his lead. It was a comment by Professor Williams. You referred to the tardiness and timidity of the International Criminal Court. I'm just wondering whether that comment might not underestimate the time it does in fact take to investigate and get to the point where you can actually have an indictment. And secondly, whether it doesn't rather gloss over the fact that at that point all you've got is an indictment. You don't have any judicial decision, leaving aside the question of how far a judicial decision is really the governing point in the decisions that you were considering.
Yeah. Well, that's important. And there is a distinction between an actual indictment and a conviction. From your bio, you represented Krajisnik, right, in defense?
Correct.
Yes, he's my favorite example of timid and tardy, so I'm glad you asked this question. The story that the story that I like to tell, and I do agree, there's some nuances in this, but the story I like to tell is that 3 of the 4 individuals who signed the Dayton Peace Accords, and I believe Prajznik signed as well, were subsequently indicted or convicted, or in the case of Tudjman, we would have indicted him, but he died, according to the prosecutor. Prajznik, who was subsequently, despite your best efforts, convicted of genocide. No. Give him the microphone.
As I introduced this afternoon, no, he was not convicted of genocide. I want to make that perfectly clean, straight off. A bit more of explanation than that this afternoon. But I was just as a kind of introduction, I was very amused by your comment about getting to yes in relation to war criminals, just because Mr. Prajznik was always known as Mr. No, wasn't he?
Yes, he was. He was. So I was getting to know. But he did, after signing the Dayton Peace Agreement, was elected as one of the presidents of the rotating presidency of Bosnia, and served for his full 2-year term as one of the presidents of Bosnia, doing his part to, in his way, implement the Dayton Peace Accords before he was subsequently indicted and then arrested and then tried. And so one of my concerns about the nature of the mechanisms that we create, they sometimes tend to be very slow. For maybe legitimate reasons, or for logistical reasons, or for reasons that my 2 colleagues here to the right are very familiar with, in the Milosevic situation, I'm trying to bait them into this debate here, are simply slow to exercise their judicial prerogative to indict and then prosecute. And you had this with Goldstone. He was very proud of the fact that he indicted Karadzic and Mladic prior to Dayton, and thereby, and he'll say this, kept them from the Dayton negotiations, which always leads to the second question of, and so why didn't you indict Milosevic? And then he has a number of answers as to why he was unable to do that, because didn't have the evidence and the legal case they were pulling together. But I'm hoping I've enticed my 2 colleagues here to tell some stories about the Milosevic indictment during the Kosovo air campaign.
Unfortunately, with very little time left, I'm sorry to say. But we do have one last question. This is actually from our overflow room, so we're delighted to get a question. We haven't forgotten about you guys in the overflow room. And it is this, for any member of the panelists who'd like to take it, any member of the panel. Would you say that racism is a potential precursor to genocide? If not, what is? Big question. What do you think?
I don't know that I could address that specifically, because I think racism does exist in so many societies, maybe in most societies in some form, until they come to terms with it, as we did in the United States through the civil rights era. And we haven't completely finished it, so I'm not sure that necessarily follows. I think that the precursors for a genocide are a general attitude toward minorities, that they are not just minorities, but they are inferiors. You have the hate speech that you can find in the media of superior powers, or elites who decide, to basically turn people into pariahs, or whole groups into pariahs. I think when you see, and I can just witness this from the series of Balkan Wars, the first signs that we all missed, but that were there occurred in the first of the series of wars, or maybe certainly the second, in the Croatian War, where you could see that the Yugoslav army and militias that it was supporting essentially were out there committing a variety of war crimes under any definition that was very widespread. I just remember that the bombing of the hospitals throughout Croatia, the deliberate destruction of hospitals which were not being used for any military purpose except for caring for the wounded. And you had a pattern of that, which I certainly missed, and I think maybe even the ICRC did. Never made a point of it, but it was a first sign that they were testing the system, and the system let them get away with it.
Let me add one thing, two sentences, Judge. You can take any ism, racism, sexism, extreme religious extremism, those are in many cases a precursor. But to me, it's the virulent nationalism, to use the phrase from the World War II era, that serves as the method of transmission. that's a real big early indicator. When you're able to use nationalism to create a we-they sort of a syndrome, you're creating your target population. That's the precursor that then leads to a whole other series of identifiable factors.
I'd ask you to help me thank our panelists for this superb panel.
Thank you, Melissa, and this wonderful Crossfire panel.